The following is a Metro TV special presentation.
I'm Carolyn Miller Cooper, Director of the Louisville Metro Human Relations Commission, and I want to thank you to the Community Forum that we are co-hosting tonight with the Stand Up Sunday group. Ms. Helm is a representative of the Stand Up Sunday group, and we are talking tonight about jury pool selection and what does it mean to be a citizen. And before I bring Councilwoman Green up, we have on-site voter registration. So please, if you are not registered, if you know someone that is not registered, get the form and let's get them registered. Thank you. At this point in time, we're going to have Councilwoman Green.
Good afternoon, everybody. Thank you for coming and welcome to beautiful District 1. So I'm happy that you all are here. This is a very important issue. It has garnered some significant attention in our community recently. So I'm happy that Stand Up Sundays and the Racial Commission has brought this forum to our community. Thank you to our distinguished panel that is here. I have seated juries as both a prosecutor and as a defense attorney. I made it actually onto a jury panel once, was not actually ever selected actually for a panel. And so there is much work and much discussion that we all can do to try to increase diversity. And there are questions that should be answered and questions that should be asked about why there are not significant numbers of minorities in such panels. And so I know that all of you all have a lot of questions that are out there. I know that all of our panelists have questions, they have answers for you, and all of these individuals have much experience in their various fields. And so we welcome you, we invite you to engage in this process. And so I'm just excited, I'm on tiptoe anticipation for what this discussion will bring. And so we have brought together individuals from various portions of the sector, various specialists, and so I'm just excited. And so welcome to all of you all, and we're ready to get this show on the road. So thank you all.
Okay, I am going to introduce the panelists. We are short 2 panelists. I'm sure they'll get here over the course of time. So I'm going to introduce from my right, your left, going in that direction. So first we have Commonwealth Attorney Tom Wine, or Thomas Wine. He's the Commonwealth Attorney and was elected in November of 2012. He has the duty to seek justice for all, and prior to becoming the Commonwealth Attorney, he has served as a Circuit Court Judge and on the Kentucky Court of Appeals. So Tom Wine. Then we have Judge Denise Clayton, who is from the Kentucky Court of Appeals, the 4th Appellate District, Division 2. She's the first black woman to serve on the Kentucky Court of Appeals, but she will not be the last one, and began serving in October 2007. Prior to her appointment and election to the Court of Appeals, Judge Clayton was Chief Circuit Judge for Jefferson County, where she had been a circuit judge for nearly 7 years. She is the first black woman to be a Kentucky Circuit Court judge, and she is the chairwoman of the Chief Justice's Commission on Racial Fairness for Jefferson County's courts. So I give you Judge Clayton. Sam Marcosson. He's a law professor at the University of Louisville, Louis D. Brandeis School of Law. Professor Marcosson graduated from Yale Law School in 1986. After clerking for Judge George Pratt on the Second Circuit Court of Appeals, he joined the appellate staff at the EEOC in Washington, D.C., where he spent the next 8 years briefing and arguing cases in the federal courts of appeals. Since joining the U of L faculty in 2004, his research and writings has concentrated on constitutional law, especially the 14th Amendment. Now, who knows what the 14th Amendment is? All your students. Good, good, good. The rest of you, talk to her students, please. And the civil rights issues facing LGBTQ community. So I give you Professor Marcosson. And then we have Chanelle Helm. She's the Enlace Prison Divestment 2015-2017 Fellow. Ms. Helm's efforts have been focusing on hyper-criminalization of women, centering on reproductive violence. She's a community activist and organizer with Stand Up Sunday, hosting Stand Up Sunday every Sunday at 3 p.m., conversing on topics that relate to Black Lives Matter. Ms. Helm. The two individuals that we are missing are Senator Gerald Neal. He's the Kentucky Senator for District 33. He was the first African-American man elected to Kentucky State Senate and was elected in 1989 and has since been re-elected consecutively the last 23 years. And he represents the longest service for any African-American member of the Kentucky General Assembly. And we're also missing Attorney Edward C. Monahan, attorney for the Department of Public Advocacy. Attorney Monahan began his service as a public defender in Kentucky in 1976. In the ensuing years, he held several leadership positions, and on September 1st, 2008, he was appointed Kentucky Public Advocate by Governor Beshear. In that position, he oversees the administration of Kentucky's statewide public defender program, which represents over 150,000 persons a year. So he will also join us shortly. Okay? So at this point in time, I'm just going to start with Tom Wine, Commonwealth Attorney. Are you ready?
We're ready.
Okay, go ahead.
All right. Well, thank you all very much. There were a couple of topics that I wanted to touch on, and fortunately, I've got an idea of what some of the other panelists are going to talk about as well, so we'll try not to repeat each other, and I'll try not to steal their thunder. One of the things that has come up recently and has been an issue that we've tried to deal with for a number of years is how do we increase minority participation in our jury system. And of course, it's gotten a lot of attention recently, but it's always been an issue. It's been an issue since I was a prosecutor starting back in 1980. It was an issue when I was the chief judge of the Jefferson Circuit Court back in 2000, and it continues to be an issue. And so people look to, well, okay, what's the issue? How do we get more people in? And one of the things we talked about was increasing or expanding our source list. Back in 1980, when I first started, we got our jurors from one list only, and that was from voter registration. If you were registered to vote, you were liable to be called as a juror. And we found out that that wasn't expansive enough. We needed more representation from the community because not everybody votes, unfortunately. So they added driver's license rolls. And that held out for about 20 years until just a few years ago when we expanded again and used records from the Revenue Department, people who are on paying any type of taxes, to get those names as well. And you may appear on all three of those lists, but you have the equal opportunity as anybody else who only appears on one list. I remember one time we were picking a jury and a gentleman said, "I don't know how you got my name. I'm not registered to vote." And we said, well, got some bad news for you. Last year they changed the process and we added driver's licenses. So you'll have to give up your driver's license as well if you're trying to avoid jury service. And that's what he was doing. He would not register to vote, so he would not have to serve on a jury. Kentucky has probably one of the more expansive lists of trying to get people from the community involved. A lot of states only use one source, so we use three. And we're looking to expand that even beyond the three. Some talk about using government-issued IDs. If, for example, you have a TARC pass, if you have something that allows you services through the community that you're not on the other three, you would have the opportunity to serve as well. So that's very important that we expand it. We've also talked about even using things like church rolls. And I tell people all the time, they go, well, how do you avoid people cheating? You know, somebody gets on a list just so they want to serve on jury. I want to ask you, you don't have to raise your hand, but how many of you keep hoping every day you're going to get called on jury duty so that you can serve and serve at $12.50 a day and give up your rate? So we got a couple of hands, so all right. So, and that's good, and I hope you get called. We have a random system, and somebody will say, well, I've never been called. Well, this year I'll be 61 years old, so I've been eligible for almost 41 years to serve on a jury. I've been called once in 41 years. Now, I've had juries where people say, this is my 5th time I've been called. How come I've been called 5 times and my neighbor's never been called once? It's a random process. I can't answer that for you. Why have I only been called once? I can't answer that. So another thing we looked at, okay, well, if part of the problem for people serving is that it's expensive. And when I say expensive, you're giving up your salary. We pay $12.50 a day. That's how much we've paid since 1976. Is there anybody here who thinks they can buy anything today at the same price that they got it for in 1976? And the answer is no. If we adjust jury pay for inflation, you should be getting over $40 a day for jury service. We've tried before to get it increased, and it hasn't happened. But we also know from other states' experiences, when they raised jury pay, it didn't increase the number of jurors coming in, because you can never pay somebody enough. If you're making minimum wage, say $7.50, a little over minimum wage, $7.50 at 8 hours, you know, that's almost $60. We'd have to pay you $60 just to equal what you're earning minimum wage. So that just doesn't happen, and that's a problem. Another issue that we'd like to talk about today, and I'm sure we're going to, is there anyone who is, why don't we have on our juror qualification forms what people's race is? The juror qualification form simply asks information about your date of birth, where you live, the number of children you have. It doesn't ask anything about your race. And a decision was made a long time ago not to include that information for fear that somebody would purposely go through the list and say, oh, this is an African American, I don't want him or her to be in the pool. Well, now it makes it difficult for us to track, and I'll let Judge Clayton talk about how she came up with a resolution for that, but it makes it difficult to track as to how many African Americans are serving in the pool or any other minority. So that's an issue that we have to deal with. And I'm hoping somebody's timing me and telling me to shut up. With my
Yes, I'm timing.
Okay? Because I got a lot, okay, so somebody will raise their hand and say shut up, thank you.
You've got 5 more minutes.
Yes, you do.
Hi, Carol. How are you?
Is anyone automatically excluded from jury service? And the answer is no. Whether you're a doctor or a lawyer, whether you run a gas station, no matter how old you are, the only automatic exclusion is that you're not at least 18. You have to be able to speak and understand the English language. You can't have been convicted of a felony and subsequently pardoned. So if you get a pardon, you're allowed to serve again on jury service. I think those are the 3 big ones there. So you've got
Got the other ones.
you have to be a resident here in Jefferson County and a resident of the United States. So those are the big, so we have people who get called, unfortunately, because we don't update our list, because they're dead. And I know it sounds silly, but I had a lady write to me one time when I was chief judge. She said, I told you 2 years ago my mother died. She's still dead. They don't do a good job of updating the list. We finally got in medical excuses. If you have a doctor that says I'm 80 years old, I have trouble moving around, I really can't serve, that can serve as a permanent, but you still get a summons, but you can at least provide that information so that you'll be excused. I think one of the biggest issues, aside from everything I'm telling you here, is that we do want to try to work to convince people that our jury process is a fair process. It works best when everybody participates. No matter what your age, no matter what your social background, no matter how much money you make, no matter what your race is, we're a mixed, diverse community. And it takes everybody together to make a difference. And we believe that, we work hard on that. And I still also know from experience that it's important that when you get that jury summons, and I've talked about this before in some community forums, instead of trying to figure out how you're going to get out of jury service, you ought to figure out how you're going to get down for jury service. And that applies to everybody. This is our community, and we have a vested interest in making sure that we keep things safe, that the right people are punished, and that the right people who need to be acquitted are acquitted. So it's important for us all to be involved in that process. So that's it.
Okay. We're going to move on to Judge Clayton, but again, for those of you who arrived recently, if you're not registered to vote, if you know someone that's not registered to vote, I have my friend here, voter registration, okay? So this is how I think. Everybody in your circle If they are eligible to vote, they should be voting. So if you know of somebody, make sure they get registered, please. I don't want to get political, but we have a big presidential race coming, okay? I'll just leave it at that. Judge Clayton. And everyone has 10 minutes.
That's exactly. Yeah. All right. Good evening, and thank you for inviting me to participate. I'd like to go back and give a little background about the Racial Fairness Commission for the Jefferson County Courts, as well as a little history regarding juries generally. As you heard Mr. Wine say, we have 3 source lists. We're looking at expanding. I think Senator Neal has an issue with, or presented a bill regarding expansion of the list. But currently in Jefferson County, from our tracking, which we believe to be accurate and valid, we have, as far as jurors coming in to serve, usually about anywhere 13 to 18% of those jurors are African American. We know that African Americans are present in the pool. We know also that the demographics of Jefferson County for African Americans is a little over 21%. But we also know that not all of the 21% are eligible to serve on jury duty. And that's because of some of the factors that Mr. Wine indicated. But the largest factor that would exclude is the fact that individuals who are under the age of 18 may not serve on a jury. We know that of that 21%, about 6% are minors. So therefore, the eligible number or percentage is really about 15%. So we know that we do have jurors who are receiving notice. We don't have any proof, frankly, at this point, that there are individuals who are trying to avoid service. We do have a number of summons where people have said they were going to appear but didn't. But we also have an issue with making sure we have valid addresses. So there are some issues with it. But we do know that individuals are being asked to come in. We have no proof of any kind of systemic exclusion by the system of anyone. I know that, you said you've served once. I've been on jury duty 3 times. And one of those times I served as a juror on a criminal case and a civil case. So everyone who is eligible to serve, in fact, is encouraged and expected to serve. As you may or may not know, the history of terms of exclusion of African Americans in the jury system dates obviously back to a very long time. In the 1930s and 1940s, we did have a series of U.S. Supreme Court cases that basically said you could not deny African Americans the right to serve on a jury. And what they're looking at is systematic exclusion. That is, whether or not the legislature or the courts or administrative agencies or attorneys making what they call peremptory strikes. That is, those are strikes that during the course of seating a jury, both the defense attorney and the prosecutor can ask for jurors to be removed. We know that through Batson, I know Professor Marcosson is probably going to address the Batson case, but what we know is that the attorneys are not supposed to use race as a basis for exclusion. So that's sort of where we are. The system is not allowed to exclude any African American from serving. So what our Racial Fairness Commission looked at, and our report was issued actually back in 2007, we looked at those issues. We looked at issues as to why people may not appear for jury service. And one of the biggest reasons that we found was actually medical. People's health would often give that would be their reason for why they couldn't serve, and that medical information had to be documented. So we know there are different reasons why people may not serve. We also know that loss of income is an issue, as you've already heard discussed. An employer cannot fire you if you're called to jury service. But also, unless there are certain employees, most employees don't have to pay you either. So you can certainly go serve. You will not lose your job, but you also will not get paid. So that is obviously a barrier to that. And it's not just a barrier in terms of individuals making maybe low-income wages. If you have your own barbershop, if you have your own beauty shop, if you have your own business of any sort, and you're not there to conduct that business, that creates a hardship. So people are excused, but not forever, usually, from jury service. So at some point, they will be called back to serve. You've heard the qualifications for jury service. And those qualifications additionally also include that you can't be presently under indictment, and that if you do not have to serve if you've served within the last 24 months. So there are some individuals who can be asked to be excused from service. So I think if you look at where we are in terms of making sure the system doesn't exclude, then you get maybe to the next issue that has been before the community, and that is the certification of law issue. That's the issue where the judge decided that based on the lack of diversity in the panel, that panel should be dismissed. Certification of law is something that the court itself, the judge could ask for the law to be certified, or in a case where the Commonwealth has not prevailed in a criminal action, they can ask for it to be certified. Not prevailing means that the defendant was acquitted. So certification of law has nothing to do with the underlying criminal case of that defendant. What the certification question is basically saying the law has been one way, now it appears as being interpreted differently. Can you, Supreme Court, tell me what the law is? And what, if you're following, and I hope I'm being clear enough about what the law is systematic exclusion. If you don't find systematic exclusion and you dismiss the panel for some other reason, then that's doing business a little differently than the law has said you're required to do it. So that's what the question is before the court, before the Supreme Court. You should also know, though, that what each trial judge does in his or her own courtroom has no bearing on any other judge. It doesn't make any difference what I do in my courtroom as when I was a trial judge or anyone else. If I want that change to be made permanent, somebody needs to appeal it. And the only way to have that, therefore, if we want to look at whether or not it should be changed to allowing looking at the numbers and saying we need diversity on the jury, and that's enough to trigger dismissal of the panel. The Supreme Court has to be the one to make that decision, because otherwise what you have is one court doing it one way and another court doing it another way. So you don't have the consistency. The other thing you have to realize is that Kentucky has 120 counties. So this has to be able to work in all 120 counties. So that's what the certification of law issue is really saying. Just tell us, how do you go about seating a jury? And then whatever the Supreme Court says, that would be the law unless that decision is appealed. So that's the issue of certification. So really, and every trial judge has been appealed. Being appealed is no big deal. You may not like it, you get your feelings hurt a little bit sometimes when a higher court tells you you were wrong. But the truth is, that's how law is made. Law is not made in the individual courtrooms. Law is made when it goes to a higher court for the court to say, this is what was done here, this is right, everybody now needs to do it. So that's the issue that's pending before the court. And the only way to get that issue resolved is for the higher court to make that ruling.
Okay, we're getting ready to move on to the public defender, Mr. Monahan. Now, I do have to confess, 20 some odd years ago when I first started practicing, he was my boss's boss, I believe. I'm not really sure. He was in the big office in Frankfurt, and I was down in the little office in Paducah. Okay? So,
The professor's going to go next.
oh, okay. Well, I did not work for the professor, but we're going to have the professor go next. Okay? So, Professor Marcosson.
Thanks very much. You know, it's interesting. The first two speakers have talked about the times that they were on called for jury service. And the irony of that is that I've also been called for jury service in the 20 years I've been in Louisville twice. And the most recent time proved to me there are no such things as coincidences, because it was last October, and I was actually on the veneer that replaced the veneer that caused all of the controversy we've been through as a community recently. And so I'm here in sort of a dual capacity. Law professor by night, innocent veneer person by day. And so I want to relate just briefly something about that experience before I talk about some of the legal issues. Because I think it's some of the details of what happened in Judge Stevens' courtroom might be interesting from my perspective as somebody who got rejected for that jury. In fact, I got rejected for all juries because no lawyers want a law professor on their jury, believe me. But what was interesting is that two things were interesting. One is after I did get rejected and I went back downstairs to the jury assembly room, all sorts of little rumors started to spread about, oh, I heard about that jury, and do you know that's the second time a jury was called for that case, and no one knows really what's going on. So it immediately began to become a thing, and no one until about a week or so later knew the reasons. And so I was very curious, of course, what might be going on. But backing up, I just want to tell you that during the jury selection process the second time around, in the case that sparked a lot of this, at least, the prosecutors who were on the case, and I may be a little biased here because they're both former students of mine, and who I regard very highly, conducted themselves completely professionally and impaneled a jury that was diverse and a reflection of the community, and that, although I don't know if this ever got reported, Mr. Wine might be able to tell me more detail about this, but that jury convicted the defendant in the case, and in what was ended, for all the reasons, was a pretty routine drug case in a lot of ways, at least as far as it was described during jury selection. And I think those kinds of things can get lost about in the controversy and the headlines about the routine business of prosecutors doing their job and doing it in a way that can get lost. So that was part of my experience, having been there at least the second time around. And I'll be happy to take questions about what that experience was like during questions. What I really want to talk about, though, is the legal foundations upon which courts proceed, and which I think maybe would improve that system to make for more diverse juries, and that judges should be able to do. As Judge Clayton said, the Supreme Court decided 30 years ago, actually, that prosecutors, defense attorneys should not be able to use their peremptory challenges to strike jurors on the basis of race. And that if there is an indication, a basis, that they can make a showing that race might have been the reason, an attorney can be forced to explain the basis for his or her challenges of jurors, and that if those explanations are found to not be valid as a reason for why jurors have been struck, that a court can hold that there has been a violation of the Batson rule, and and that jury selection would then be nullified in that case. And the problem with Batson is twofold, and why I think Batson is an inadequate response to the problem of fairness in juries, the need for cross-sectional juries, and the need for diverse juries that really reflect their communities. The first is that it hasn't worked even in dealing with the problem of race-based peremptories, because judges have, it has been well documented in too many cases, in too many studies, judges have accepted inadequate explanations. Judges have accepted explanations that just don't pass the straight face test, and so it has been a toothless remedy for the use of race in peremptory challenges themselves. And so Batson itself, even as to peremptories, needs to be beefed up, if not, and many have argued that we shouldn't even allow peremptories anymore because Batson has been a failure. I don't know if I go that far, but we certainly need to do more than just Batson about peremptories. And then second, in my view, as we've been addressing here, you don't even get to Batson if you don't even need Batson, or Batson does you no good if the veneer from which the jurors are being chosen is not diverse in the first place. If you have a prosecutor who, unlike the prosecutors who were involved in the case that I was on the veneer for, who are determined to have an all-white jury, right? If you do have that kind of a prosecutor, they don't even need to use peremptory strikes to get rid of the minority jurors if the veneer is all white to begin with. So you have to have a diverse veneer. And it seems to me that what Judge Stevens was getting at, and we can talk for a very long time about whether he went about it the right way, and whether, et cetera, and I think that there were problems with that, but what he was getting at was that the lack of diverse veneer, at least in certain cases, undermines confidence in verdicts, in the fairness of the criminal justice system itself, and which is already shaken by major problems in the criminal justice system. And it seems to me that the argument that the judges in criminal cases should have discretion, guided by a number of factors that I think courts should develop, Supreme Courts, as Judge Clayton suggests, that they should set forth, here are the factors guiding your discretion, to say, in this case, under these circumstances, that veneer is not adequate to meet the needs of the criminal justice system, to foster confidence in the verdicts, that needs to be cross-sectional to begin the process with, so that then, if Batson is beefed up, peremptory strikes are not exercised in a discriminatory way, communities have more confidence, and the criminal justice system can at least begin to repair the damage that's been done to people's confidence in it. It seems to me that that is one step in the process. Unfortunately, this community has had this issue broached in a way that has been that has not promoted a discussion that is unifying and that has had more heat than light. Hopefully, I would certainly appreciate it and like it if tonight and other dialogues like it reverses that trend, and we can talk about positive steps that can both begin those repairs and produce ultimately more diverse juries that represent our community.
Okay, before we go to my former boss's boss, I want to remind everyone that you have cards on the table, and please write your questions down. Staff will come around and collect them, and then when we're done with all the panelists, we'll have questions and answers. The other thing is there should be some survey sheets on the table. Please be candid. Give us your comments. We want feedback. So, now we will have Mr. Monahan. And he is the public advocate for the state of Kentucky.
Thank you so much, and I'm delighted to be here. I'm not here really to talk so much about the individual situation going on here in Jefferson County. I'm not highly informed about that. I know what I've read in the paper, some conversations I've had, that's for others to talk about. I'm here to talk about the fact that we all know in this room that there is illegitimate racial disparity in our criminal justice system. We all know that. Now, it's our responsibility together to work to eliminate it and to do it now. The issue talked about over here about the proper selection of jurors is a very important issue because jurors determine the life and liberty of people. It's a part of a larger context. And I want to take a minute to talk about the larger context because until we fix the larger context, we're not going to be able to fix this jury problem. A couple of facts. In 1985, there were 5,700 people in prison in the state of Kentucky. Now, today, there are 22,405. That's occurred over that course of time while the crime rate in Kentucky has been dropping. 17% drop. A 31% drop in the violent crime rate. Now, most people, you go out here on the street and you say, is the crime rate the same, going up or down? Most people say the crime rate's going up. That's because we all have a PhD in media criminology. We watch the evening news. The reality is the crime rate's going down. It's going down substantially. The other thing is Kentucky's crime rate, both its general crime rate and its violent crime rate, are substantially lower than the national average. Few people know that. Since 2007, there are 42,000 fewer cases in the criminal justice system. That makes sense because the crime rate is declining. A lot of people don't know that. But our prison population is now ballooned to 22,405 people. It's gone up over 1,000 people in the last year, 1,000 more people in our prisons. In 1990, we spent $140 million on our prisons in Kentucky. This year, we're spending $536 million. Now, when you look at some of the statistics were talked about in Jefferson County, and the African-American rate is, as Judge Clayton said, 21.5%. Interestingly, though, if you look in Jefferson County, the non-white percentage is 30.7. There's just under 5% Hispanic or Latino. So the non-white rate in this county, and Judge Clayton has talked about the 18 and over rate, which is what it would be for jurors. I don't have that number with me, but nearly 31% of the people in this county are not white. But if you look at the African-American rate in the state, it's about 8%. Now I'm going to give you some statistics. So the African-Americans in this state are 8%. 15% of all arrests in this state were of African-Americans. 17% of all arrests for serious offenses were African-American. 22% of our prison population is African-American. 30% of our confined juvenile population is African-American. 8% in the state. The rate of imprisonment in Kentucky shows a stark racial disparity. We can't ignore this. We cannot ignore this any longer. 425 white inmates for every 100,000 whites in this state, but 1,412 African Americans for every 100,000 African Americans. That is an astonishing disparity. Now, Michelle Alexander, who you all know better than I, has written an important book, one that should be required reading by all of us, especially in the criminal justice system. She characterizes this increase in the following way. She says it's been racially motivated and calls for broad remedies. Quote, Mass incarceration is metaphorically the new Jim Crow, and all those who care about social justice should fully commit themselves to dismantling this new racial caste system. We must put our minds to this collaboratively. Look at the disenfranchisement rate in this state. We distinguish ourselves in a negative way. We have the third highest rate of disenfranchisement in the country. 1 out of every 14 Kentucky residents is disenfranchised because they have a felony. It's 3 times the national rate. We have the second highest African-American disenfranchisement rate in the country. More than 1 of every 5 Americans, 5 African-Americans in Kentucky is ineligible to vote and therefore ineligible to serve on a jury. That's triple the national rate. No wonder our juries don't have a fair cross-section. No wonder. Now you look at our public defender data, so this is only cases that public defenders are representing clients on, and I'll just give you one example that raises serious questions. In juvenile prosecutions in which public defenders provided representation for first-degree robbery, 58% of the clients were African American, compared to 24% who were white. You look at the number of cases of juveniles transferred from district court to circuit court, of those that public defenders represented, 59% were African American. You look at the adult heroin data that, again, is just our public defender data, so it's not all cases in the state of Kentucky. It has limitations. But what it shows is people charged with a heroin offense, they're charged with possession, are overwhelmingly white, 92%. Those charged with trafficking were 50% black. You just heard a discussion about the Batson case. There's another case up before the United States Supreme Court. It's a Foster case, a man sentenced to death in Georgia in 1987. Finally, through an open records request, the notes of the prosecutor in 1987, this is a man sentenced to death in Georgia. It's a case that's been argued in the Supreme Court of the United States. It'll be decided here shortly. The notes, it's not big enough for you to see, but the notes of the prosecutor, after every African American, there's a B. And here are the reasons given in this case for striking those African American jurors. The juror didn't keep eye contact. Juror looked bored. Juror was a social worker. We didn't strike them because they were African American. We just struck them because they didn't keep eye contact. It's important that we all pay attention to that case, because it's going to tell us whether or not, as the professor has discussed, Batson is going to be evolved to have some teeth. People, what do people want? People don't want this system because they don't have confidence in it. Mm-hmm. You ask people generally, and they believe that minorities, low-income people, and African Americans are not getting a fair deal in the criminal justice system. How do African Americans see the system? 77% of African Americans think offenders of their racial background get worse treatment in terms of their sentences, and 70% feel the same way about low-income people. Hispanics also believe they're not getting a fair shake. Illegitimate racial disparity in the criminal justice system results when you results from dissimilar treatment of similarly situated people based on their race. It exists in our criminal justice system. The data is speaking to us. Again, Michelle Alexander, we have not ended the racial caste system in America. These are strong words. We have merely redesigned it. Now, I'm a hopeful person. I am a hopeful person. I believe when people understand the context, that they will be motivated to action. And there are reforms. Senator Neal has introduced legislation. Representative Yance has introduced legislation to allow people to have their felonies expunged, to no longer face an economic death sentence. There are broader reforms that have been filed in this 2016 General Assembly which would reduce some low-level misdemeanors down to violations, reduce some low-level felonies down to misdemeanors, take a persistent felony offender law that says you shall if somebody has prior and says you may, requires the parole board to parole people who are found to be low risk instead of keeping them in prison for longer. And on and on. It would save the state over $20 million, estimated. We could use that $20 million to help people re-enter from prison. But if you have a system that pulls in all of these people into our criminal justice system and does it with this disparity of race, guess what? They're not available to serve on juries. They don't have confidence in the system to come down to the courthouse. Are we surprised? Now, the certification of the law is an important way to clarify the law, and that will be done over here. But I call on all of us to look at ways to reform our system so that not only juries are fair cross-section and people have a fair chance to have their life or liberty decided by a fair jury, but to look at this larger system that is dragging us all down by incapacitating people based on their poverty and their race.
Thank you. I'm going to let Councilwoman Green make a brief comment, then we're going to turn it over to Senator Neal for his comments.
I want to say that I don't know what certification of the law will yield in this particular instance. However, as it stands, the law, in my humble opinion, is not good enough for any of us. We have a system where young black boys and young black women are brought into a system where they have no confidence at all in the system. We have a police force here in Jefferson County that is 9% African American with almost a 22% population of African American here in the city. And so you walk into a courtroom where you're most likely going to get appointed a white public defender. You walk into a courtroom where you're going to see a white judge on the bench. You walk into a courtroom where you're going to see a white prosecutor. And when I was there, there were two or three at most when I was there. I'm not quite sure how many are there that are not. You walk into a courtroom where at best there may be one, maybe two if you're lucky, black jurors on your panel. And this process is supposed to be fair to you when you're the only black face in the room, and you're supposed to trust that walking out the back door, you're going to have a fair chance to really walk out the back door. The process in and of itself is inherently flawed, and so we've got to find creative ways, to pull from different lists. So whether it's to pull from benefits lists and try to get people there, I don't know what the answer is, but those kind of folks, they really can't afford to be there to serve on panels. Those folks can't afford to be there. So I don't know if it is that we pull from those lists. I don't know what the answer is. All I know is that it's going to take all of us together trying to come up with an answer. But for anybody to really believe that people of color who are inundated in the system would really feel that this process is fair and have confidence in it. I think that you are naive, and unless you are the young black person, you probably wouldn't understand why we need a little bit more representation in all areas.
Senator Neal.
Well, thank you very much, and good evening, everyone. I'm sitting here just thinking where I was going to go with this. I think I'm going to go somewhere else with it for a moment, but I do want to share what I have. You know, we're here primarily dealing with issues that relate to race, as it relates to the jury system and the systematic exclusion of African Americans and other minorities from the jury pools and therefore the juries themselves. But there's another aspect to it as well, because we have a system that we have, the pools are predicated upon what we've identified, whether it's the tax rolls or whether it's the property rolls or something of this nature. Fact of the matter, we have people out here that's not on any of these rolls, and they don't have an opportunity actually to be considered for the jury pool as well. And that's what's led me to the filing a bill regarding the IDs. Those who have IDs that do not have driver's license, that do not otherwise appear on these various rolls that are lists that they're pulled from, that these individuals would broaden if they're added for consideration with respect to lists and expansion of the jury pools. Now, this idea didn't come from me. This idea actually came from the work of Judge Clayton and her panel. That actually, and to their credit, and I congratulate the efforts in trying to diversify the jury pool, notwithstanding the fact that they're reporting that there's no systematic exclusion. I believe that's correct in terms of the report, right? But I think the point, though, is not whether there is or not. The question is, and it keeps being raised the whole time we're talking here, and that is, the confidence people have, the credibility of the criminal justice system. You know, if you believe that it is unfair and it is part of what you live by, it's part of what you hold high as an ideal in your society, and you do not have confidence in it, then that's right there is a death stroke to a democracy. You know, you have to believe in the democracy. You got to believe in the institutions that it has. Now, we all know we have a very challenging history in the United States of America, as well as in this community here. And sometimes, you know, in the legislature, when I deal with some of my colleagues, it's almost as if they acknowledge it and then they don't acknowledge it because their behavior doesn't follow the recognition that we do have this particular history. And therefore, trying to get them to understand quite frequently that changes have to be made is a very difficult thing to do. They live a different reality, they perceive it differently, and they carry baggage like all human beings do when they go through a particular history. So this ID law, I think, is at least a demonstration of how we should and can proceed, but I just found out today that the law was recommitted to the Judiciary Committee. Now, you would think that that's an extraordinary thing for leadership to do to a bill that is so common sense, that does no harm at all, but in fact would lend itself to more credibility in the system. That behavior wouldn't manifest itself, at least in where I live, which is in the Senate. But I'm sad to report that although the process is not completed, that's what took place today. That's a question that the people in this audience here and the people at this panel here should be asking, because we are in legislative session. This is the opportunity to deal with it. We can talk about it, but there is an opportunity to deal with this issue. Now, what I do want to do, though, is go a little bit further. Did a little research. I don't know if this was mentioned before I came in or not, but there are some alternative methods of diversifying jury pools beyond ID cards, for instance, and I'm going to list some of them. And this is something that can be done partially by legislation, but also by the Supreme Court, at least in part. adding lists of welfare and unemployment compensation recipients to existing jury selection lists. I think that's a no-brainer to me. I'm not sure that takes place. I doubt if it does. It does not take place. Soliciting parishioners lists from local places of worship. Sending at least 2 notices of jury duty to prospective jurors. I don't know if we do that or not, Judge Clayton. In other words, we should be a little more intentional, a little more persistent in terms of our outreach. Easing the burdens of reentry, which in part we were just talking about in terms of expungement as part of it. But easing the burdens of reentry on citizens who have been criminally convicted, they may not be able to serve on a jury. Because if you're convicted of a crime, you are automatically excluded, and particularly as it relates to juries, not just voting, but also jury participation. Increasing the amount of compensation for jurors, I think it was mentioned here, who may face economic hardship through service. There's a combination of how that manifests itself, and I think Judge Clayton related this. But this is the one that I think is a really, this one's a good one for me. Creating a geographically based selection system in which the zip codes are particular political districts of prospective jurors who appear in court are noted. And if a particular zip code or political district is underrepresented, adjust the amount of mailings, juror qualification forms, sent to those areas accordingly. Now, if you had, I don't think there's a single answer, but I think if you have a combination of tools, tools that are tried in some other jurisdictions, maybe 1 or 2 of these, for instance. But if we were serious about this, and if we understood and that this whole thing of undermining the confidence in the criminal justice system in and of itself is a very serious matter, and it is a very serious matter, then it would seem to me that we would do all that is necessary and all that we can to regain that confidence, to lay that foundation so individuals would not only be able to participate, but we would be in a position to be able to say that we have not only a fair system, but one that's perceived as a fair system, which I think is just as important. So I'll stop right there, and hopefully I'll be able to participate in responding to any questions that you may have. Thank you.
We're going to hear from Ms. Helm, but if you intend on asking questions, now's the time to write them down, and Mr. Geddes is going to come around and collect them, okay? Ms. Helm?
Hello, good evening, and thank you all for coming out. Like she stated in the beginning, we hold a weekly meeting every Sunday at 3 p.m. to talk about issues that relate to Black Lives Matter, the movement for Black Lives, which is officially called. And one of those questions surrounding this case, once it started being dissected, especially going out in the community and asking people, were the confusion around what is a citizen, and that's the reason why this is the title of this community forum, but also to break down the situation that's involved with the case, because I'll be speaking from the community point. I think Senator Neal and I don't want to mess his name up, Attorney Monahan, did a really good job of the stats and what people were asking for, but it was really confusing to people to even understand how and what qualified you for jury duty. A lot what was being confused was what was considered a citizen or a resident, as people only thought that, owning a house, voting, and having an ID were the only thing that you had to do as a requisite for that, and that was just not true. And so more of that information needs to be out there as well. But like Monahan had reached into, is that there is a complete distrust of the system. And in 2005, which is the study that that Judge Clayton is referring to, is talking about what recommendations could be changed. That study took place in 2005, and it was raised by the community. Reverend Coleman had had asked for the study along with some others, and it was based really on whether there was prejudice among judges in the courtroom. The initial comeback from that study had stated that there wasn't really any fair amount of prejudice from the judges, but the system was flawed. So if the system is flawed, the judges are part of the system. I mean, it's like a IQ test question: are they or aren't they? So so they went back and did this, went through the study again to find out that there was some implications in that. And so what we're looking at is their follow-up almost 10 years later. I mean, like, just because they want to state that they've looked at these things and they sent out recommendations, this is 2016, this is not 2008. This is almost 10 years later that these recommendations still haven't been worked on. And so these are the things that we're looking at. And I think what Monahan should really resonate with people is that we're arresting people, we're hyper-criminalizing people first and sending them to prison based off of, just not completely even doing the work, like, to be all the way honest, not finishing the work. And I don't think citizens who live here, people who pay rent, people who pay their taxes, people who pay their mortgages, and people who earn a living don't have time to waste on whether or not we want to finish a study and then not, follow the implications of that study. And so I think that's the main part that our group wanted to point out, was that we have not worked on making fair juries for people of hypercriminalization. In Jefferson County, those numbers are 50+% entering into the criminal justice system. Out of, in a statistic that's supposed to be 20% of the population, that's the African American population, since we're just focused on Black people at the moment. That is a problem. That's really a problem. So for us, it almost was kind of like, well, do the juries need to be 50-50 if you're going to send 50% of us to jail every time that we get into a courtroom? The other issue is, what are people going to jail for? And I think that's what we've been talking about as far as people not wanting to even be on juries, trying to get out of jury duty, which they do. They go to the doctor's office and they make sure that they have something physically or something health-wise wrong with them, because that's one of the only ways that you can really get out of jury duty. I mean, they're not going to take an excuse, this is going to take away from my income, I really don't have time for this, nobody's going to be able to pick up my kids off the bus, nobody's going to be able to go get my groceries for the day, nobody's going to be able to fix my household food. These are like legitimate things that people that need to be on these juries are actually going through, and that's a struggle for them every day. And so that's something else that we find a problem with the numbers, is because we're not being able to find appropriate people to be on those juries. Would it make a difference if we dived into the list? Well, I think everything kind of falls back on itself. If you're not paying people the equivalent of what they get paid for missing a day of work or missing a day even at home, then you're not going to see those numbers rise. So what is it going to take? And I think those conversations don't need to be held centered around your own peers, which happens to be the people that you all work with, because that's not the community that we need to enter into the pools. They need to happen where those people are getting arrested the most, where those people are the percentages that we're not seeing in the jury panels, which is the problem that was at hand with this case, in which the public defender or the defendant's lawyer had asked for the reclusion of the jury. And that's the next process that we had a problem with, that it seemed like it was coming all down on the judge's head for the situation, when this is a process. It isn't something that you necessarily can just pull out of air, but if you only have an all-white jury and then you bring in a substitute and that's just one Black person, there has to be a problem with the jury pool. And I think anyone who's been a judge or even a lawyer, if the community can see that, certain people in the community can see that, then that was a problem. And that was something that I had stated at our meeting with Judge Wine when he reiterated the process, which we have gone over for over a month by the time we met with him back in December, was that we did understand that that the person that was brought in off the substitute was Black. That did not make the jury okay. And I would think that there was a problem if there was only one other Black person in that pool of just 4 people for the substitutes. That's an issue that we have to look at as well. A lot of people don't even understand what that actually means. And I think for the most part, I don't know if we can say people need to learn or people need to know. That's just not on people's radar right now, and especially while they're suffering from economic situations like we do have. And I think that is a direct correlation of why a lot of people of color in this state are being arrested at the rates that they are being arrested.
Those of you that know me know that I'm sitting there and I'm trying to keep the lid on, okay? So I'll stick to the questions that are before me. Mr. Wine admitted that the jury pool lists aren't kept up to date, and dead people of 2 years are called. If we can't keep dead people off the list, how do we keep track of transient citizens, more commonly people of color, and lower-income citizens? The technology is certainly there. Why aren't we better at using it?
Was that a question for me?
Yes.
Okay.
Or whoever wants to address it.
Well, you're absolutely right. We do have technology, and we've improved technology. The question is it accessible to everybody? There's been talk that we should use an app, if you will, for your cell phone to remind you that you have jury duty. That's a great idea, but does everybody have the cell phone, and will they have the information? People who are maybe 60 and above may not have cell phones. Maybe they got a flip phone, so they're not going to have that information. It really is difficult if you don't have correct addresses. And if you change your address, you're supposed to change it with voter registration. You're supposed to change it on your driver's license. And again, I'm not asking anybody to raise their hand, but how often do people move and they move into a different precinct, but they always like voting over here at this church or that place, and so they just go back and vote where they always voted. Well, their address has changed. So when we send out an envelope to that address, they're not there. You don't change your driver's license. And so people say, why did my license get suspended? It got suspended because the Bureau of Licensing didn't have the correct address. So you're not going to get that jury summons. So all the technology in the world isn't going to work if people don't make that basic effort. And I guess that's the best way. And I think we've proposed some things that Senator Neal has talked about in the past. It takes a legislative change. It's going to take the legislature, and I think it's unfortunate. I told you even before he got here, I thought using church rolls would be a good idea. People aren't trying to get on jury service. Face it, they really aren't. No matter how much we think we wish they were, they may be trying to get out to vote a second time. They may be trying to get that, win the lottery or whatever they have to do. There are all sorts of things people try to do. They're not begging to get on jury service. It's probably, again, one letter that you see that you wish you didn't get. I know about 3 people held up their hand and said, no, they'd love to serve, and I'm glad. I wish it was 300 every time. But we need to expand those lists, and if it's using IDs, I know, again, the Senator had some great ideas. I think all of them are worthwhile considering. He talked about zip codes, and Judge Clayton can talk about this as well. When we did the study, and we found out about, when we send out summons and they come back but people weren't served, it wasn't just one zip code. It wasn't just the zip codes in the West End or the South End or the East End. It was across the board. You look at them, they're not there. So if you're going to increase participation, are you, as a citizen who's in a zip code that's underrepresented, are you ready to come in 2 or 3 times as frequently to serve on a jury as a person who's from a zip code that's well represented? And so that's going to be the issue. Can you afford to go without pay 6 weeks out of the year instead of 2 weeks? And that's one of the things we have to look at. Are we going to penalize? When a judge gets somebody in front of him and she's got 2 kids and she says, I can't serve, and the judge says, too bad, I'm sorry, you're African American, I need you. But when the white person comes in and a judge says, oh, that's okay because we got plenty of white people, you can leave. Do we want to penalize people that way? There is no easy answer, believe me, and that's what I'm trying to say. We want a diversified jury at what cost? I mean, what's the sacrifice going to be from the community that's been underrepresented? And I think that's one of the things we have to look at.
Carolyn, may I add just one thing, just for update? Two things. One is the list that we draw from now are being looked at least annually or more frequently to avoid what that example was in terms of as we have before summoned dead people. So we're trying to avoid obviously doing that. So we are updating lists. The other thing I wanted to make sure you understand is that the Racial Fairness Commission has not just issued one report in 10 years. Our first report in 2005 was on sentencing. Our second report was on jury selection. Our third report was on the setting and establishment of bail. And our last report, done 2 years ago, was on courtroom environment, where we did actually survey individuals regarding their perceptions of how they felt they were treated, or African Americans were treated when they came to court. We also looked to the question, well, why are there so many African Americans in the system in the first place? So this is an ongoing issue, and the commission has been active actually since 2001. And I will say, prior to this most recent issue on jury selection, what we were looking at was another problem, which was the lack of referrals of African American males to the drug court program. So we are looking at several different issues, but the Racial Fairness Commission serves at the pleasure of the Chief Justice. We are not funded. We have no authority to implement recommendations. We review the problem. We tell them what's there. If judges have messed up, we tell them they've messed up. If police have messed up, we tell them that, and then we have to turn it over to individuals who can do something more about the problem. But this is not something where we've looked at once and didn't look at again and haven't looked at ongoing problems.
Okay, we're going to move on to, this is a comment and I'm going to answer it. It says no media outreach about this forum, WLKY, WAVE, WDRB, another tactic to keep the black community out of the loop and informed, thus give impression that the black community show no concern due to the numbers that show up. We did reach out. It was on WLOU. I believe it was WLKY that was just sitting back there. Trust me, they don't just drive around and follow us to see where we're going. So there was media outreach. Unfortunately, sometimes people don't show up. Life happens. You guys are here and we appreciate that. The reason why we're having this filmed for Metro TV is for those who are not here to get it. Now, suggestion, why not select from black church roles at random? Is it true that judges, prosecutors, and lawyers have personal financial connections to private correctional facilities? Let me put it to you this way. I'm just going to cut to the chase. As a former,
Over there, he can answer that. Take time.
as an ex-public defender and an attorney, I ain't get a red cent. I don't have any stocks in the correctional penal system. Now, if the rest of my colleagues are doing that, does someone here that's a practicing attorney have stocks in the...
Moore, do you have any stocks back there, Mr. Moore?
Okay. Judge Clayton, if you knew the disparity in 2007, why not, Judge? Why this has just surfaced with Judge Olu Stevens? Is that pretty much the question?
Maybe.
Yeah. Is this your question? Oh, no? Okay. So, do you want to address that last piece? If you knew there was a disparity in 2007.
When you say that, I don't know exactly what the question is about disparity. What I know is that in terms of the law saying, is the system itself excluding black people from serving, or attorneys excluding black people from serving, we did not find that to be the case. So what we know is that we have, by keeping statistics and asking the trial judges to keep statistics, yes, we knew there were times where there were juries that were not diverse. But again, the purpose of our commission was to point out those issues and to have those issues addressed by the agencies that could effectuate those changes. Some of those are legislative, as we mentioned. Some of those are through the administrative office of the courts. But all these reports have been available and out there. So anyone who wanted to work with us or come to those commission meetings, or if they have a better way to see that it gets done, that's the commission is open. But we made the recommendations, and that's not the only one we made regarding the source list. We also raised the issue whether, as mentioned here, whether or not we should have peremptory challenges by attorneys, whether or not attorneys can even have an opportunity to use a race-based exclusion for anyone. We also talked about restoration of voting rights to ex-felons. We had about 15 or more recommendations, and we have to pass those recommendations on to the agencies and the organizations that can do something about them.
Okay. Before I read the next question, I'm going to comment and say, I've been serving on the Racial Fairness Commission for close to 10 years now. So one of the things I noticed when we started hearing about Trayvon Martin and all the other incidences and some of the questions that were coming up in the community, I was like, wow, we've been dealing with this for X number of years. We've got this in place over here, and somehow not everybody knows what's going on. I'm not going to take up time with that, but we do have a disconnect in our community because we do have things going on. Trust me, Reverend Coleman, you know, those of you who remember Reverend Coleman, he was not going to sit down and get quiet until things were in motion. And once he got the ball rolling, in fact, the last time I saw him before his untimely departure was at that meeting. So we as a community need to work on making sure that the information is out there, because you've got people meeting. No, again, with that commission, there is no money. Nobody's being paid. They don't even give you a bottle of water. You come with your own water, and you do the work. Question. Yes.
Can I make a comment? You know, one thing I think we could do a lot better job on is right now, if we ask the question statewide, what is the data by race? There's nobody that can answer the question. Mm-hmm. How are pretrial, what is the racial data on pretrial release decisions? Nobody can answer the question. What is the data on sentencing? Is there anything in terms of sentencing that would cause us pause based on race? Mm-hmm. Nobody can answer the question. Mm-hmm. We in Kentucky in this age ought to know what the data is for the criminal justice system statewide. It ought to be fully transparent. Public defenders, lawyers, citizens, judges, prosecutors ought to be joining hands and saying, let's produce the data. The data speaks to facts. If we have those facts, we can then look at it and we can have opinions and evaluate it. It's astonishing we don't have. Why is it that the public defender is coming here talking about racial data on public defender data? Where is the data based on race that the state of Kentucky is producing?
Mm-hmm. Chanelle?
Have the data. Everybody you lock up got the race on there. Why you don't tell people that? Everybody that you arrest, everybody the police arrest, they put the race on it. You have the race of everybody that's been arrested.
I believe what he's saying is we're not compiling the data and distributing it statewide.
Right.
You do have it.
Okay, hold it. Okay, hold it. Thank you. One person at a time. We want to get through at 7:30. We heard his point. What were you saying, Jason?
Well, I was just saying to this gentleman's point, I think that what he's saying is there's a vested interest. And there's certainly a public defender will come here and be very specific about the data, but there are other interests from judges, from prosecutors, for example, maybe from other attorneys. People have vested interest in not letting that information get out. I think that's what his point is. Certainly, we can track any number of other things from the Department of DMV to who's on food stamps and who's doing fraud. Like you can track the data, but there are people who have interest in that data not getting out.
Okay, and then we're talking statewide. So what do we need to do if we're talking about this data statewide?
Or locally.
No what? Hold on.
That's
Chanelle.
That's what I'm definitely what Jason said, and he's actually absolutely correct. I think it's just it's very negligent to even say that we just don't know or that we don't have, as that Attorney Monahan was saying, like we need to have that data specifically for the criminal justice system. It makes up a really large part of Kentucky's history. Let's not even like overshadow that. Majority of poor and majority of non-white people, particularly black people, have made up the criminal justice system since the beginning of the state, one. Two, sometime in December, there was an article that came out when they did go through some of the numbers, and it was stated two different types of percentages, but we do know that judges do not all the time take down the race or the components of whatever the jury was made up on at the time that they see a jury. It's just not even recommended, and it's really not even enforced. So we should definitely be clear on that and let people know that, especially the people in this room, because they can take that to other places, that it's not enforced for judges to go ahead and write down the racial makeup of juries. If we want people to have a fair trial, knowing where our criminal justice system comes from, and let's be clear, the emancipation of black slaves in this country, then we should be making an effort to go ahead and do that. That should be like number one on y'all's priority list.
I agree, and I expect to see somebody better call me. We'll go sit down with the Kentucky Commission, and we'll take it to the state level, okay? A Duke University study based on the...
That's my question. Can I read it? I don't think I got it clear on that call.
Sure. Okay.
I don't need it. Look,
And I'm trying, you don't need it?
I don't need it.
Okay, go ahead.
I hear the problem about a non-diverse jury, but I think we're not looking at this from both ends. Now, if we have non-diverse juries, we need a system. We all know this is not a perfect system. And Mr. Warren, I believe you when you say that these juries are picked at random. I've looked at the data, I've looked at the system, and I understand they're picked at random. My problem is that if you pick from a community and you pick at random, there's still no assurance that you're getting a diverse jury. You can get all white jurors, you can get all black jurors, you can get Hispanic jurors or whatever the situation is. So if that happens, we need a system in place to ensure that these juries become fair. And why I say that is because Duke University did a study, and I don't know if you're aware of the study. The study took place now this is only in Florida, but it took from 2010. It showed that when black defendants were tried by all white jurors, they were convicted at 16% more than all white jurors. When one black juror was presented on the jury, the conviction rates were basically equal, 71% for whites and 73% for black. Now, I'm not saying that, I researched you, Tom Warren, and I looked at your history. I don't think you're a racist. I looked at it, I'm like, I honestly don't think you're a racist, but I think at times we get caught up in our jobs as far as conviction rates and things like that, and we don't consider that things may not be fair. And that's all I'm saying is that if a jury is compiled and it's not fair, and we all know the system, it can't be perfect. So these times when it's not perfect, if a judge is ruling on a motion to try to make things more fair, why is that being attacked?
So your question is, why is that being attacked? That's the question.
That's the question.
Okay, so, did you want to address it?
First of all, let's understand, as Judge Clayton said, there's a process of law. The only reason higher courts look at issues is because there's a controversy. If everybody agrees on something, it's not going to go to the higher court. It's only because there's a controversy that two parties can't agree and a judge has made a ruling and the parties still don't agree that we take it to the next level. So I've served on the Court of Appeals, and I served as a trial judge. I got reversed on occasion. I served on the Court of Appeals and the Supreme Court told me I got it wrong. I told trial judges they got it wrong. But it's only because there's a controversy, and as Judge Clayton pointed out earlier, that's the way we make the change across the board. It's not personal as to a judge or as to a prosecutor that we have a disagreement about what the law is. That's the only way we're going to affect a change. And that would be my hope, is everybody would look at it and say, okay, that makes sense. If you want to have change across the board, then it's got to go up. Otherwise, it's just in that one courtroom and it doesn't go anywhere else. And you know, and I appreciate you saying I'm not a racist, and appreciate you looking at my history, because that's what I've done for 30 plus years. I mean, I grew up down in Germantown, right on the edge of Smoketown. Who cares? I went to work when I was 12 years old as a caddy at Louisville Country Club. So, and I worked my way through college, and I worked my way through law school, and I never had anything handed to me. And so I appreciate it when people of lower socioeconomic are trying to move themselves up the ladder, because I know what it's like. But I also know that there are some inherent problems with our system that because I was white, I didn't face those same problems with someone who's African American or who's Hispanic or who is Asian. So I'm not stupid about that either. I know there are some inherent problems within the system, and we got to work to figure it out. So that's why in our office, for example, we started a process of allowing expungements for cases where years and years went by, they got dismissed, and they said, well, they weren't dismissed properly, they weren't dismissed with prejudice, so you can't expunge that arrest. We changed that in our office. We went back as soon as I got in. We made a change in that process. I'm all for changing, and Mr. Monahan knows this because I've been on the committee with him, with changing the level of felonies. I think, you know, when I first started, $100 was a felony. Then it went to $500. It probably should be at least $1,000, and it probably should be that we have what we call a gross misdemeanor, that somewhere up to about $2,500 is still punishable by maybe 1 year, but not a felony 1 year. So we're looking at changes on that. So I'm for that. I've served on this committee with Judge Clayton all these years. When Ms. Helm came to our office and said, I want to talk to the Commonwealth attorney about what's going on, I met with them. And I promised her, I said, I will come to community forums and talk about this issue on how we can improve jury system. I'm here, she's here. So I'm vested in the community. Aubrey Williams said, and maybe you know Aubrey, that the reason he supported me for Commonwealth attorney was because when he practiced cases against me and I was a line prosecutor, I didn't strike all the African Americans. He knew I played fair, and that's what I've tried to do with my personal life, and that's what I tried to teach our prosecutors. Misty Vantrees saw me at a party one time. She said, 2 judges granted my request under Batson to set aside the strikes ever done. Judge Clayton and Judge White. I've practiced that my entire career, and I will keep practicing that, because it's not fair to discriminate against somebody based upon their race. I believe that with all my heart, and hopefully somebody one day, the rest of us can get in tune with that. Am I perfect? Absolutely not. Am I going to make mistakes? You better believe it. But I'll do the best I can in the meantime.
Okay. Wait. Let me do this. We're at 7:30, so I would like the audience permission to move on. Okay? I'm trying to be respectful. Metro TV, can we still film? Yeah. Okay. So Senator Neal.
Yeah, I just want to say I really appreciated your comments. I think you framed it very carefully, and I think you framed it accurately. You know, the problem, as I see it, is that we're operating from a certain type of construct. And so it's like you got a little playground there, and you play inside that. And if you don't get outside of that, then nothing changes. You're playing inside of that. It's not because somebody's trying. I mean, if you look at racism, for instance, when they start talking about the structural aspects of it or the systemic aspects of it, so it doesn't even come into people's minds. It's not like somebody was necessarily trying to do something to you. I'm not putting this in a framework of racism. What I am saying, though, is if you have a construct that bottles you in, then that's where you're going to play your game. That's where your solutions are going to be. There are answers to this. if you are willing to put the combination of things together to get the objective that you define that you're trying to get. In fact, these are not all the answers, but the fact of the matter is, if you take some of these things and you're willing to go outside of the existing construct, and your objective is to, like, for instance, you say, well, look, you can end up with white juries or all whatever type of juries. Well, you know, Batson doesn't insure something like that, but that doesn't mean that you can't go outside of that and configure those dynamics and give the appropriate discretions by virtue of the Supreme Court's what would you call it, Supreme Court's rulings or whatever their position would be, to get the result that you have to. So it might take a certain amount of discretion, and judges do have a certain amount of discretion, but it may take more of a certain type in order to ensure that you have a better result, if you define that result as worthy of what I consider to be the real question is of getting trust back into the system, which is so, I think everyone has said, there's a lack of trust in the system. So I think your framing was exactly correct. I don't think this is rocket science. I think it's a matter of stepping outside of the current constructs and putting those elements together to get a result that you want to achieve.
The professor wants to respond.
I also love the question because I think it really stressed the difference between two different things we've been talking about tonight. One is, and they're both important, but they're different. And one is trying to get at conscious racism that is reflected in things like using race-based challenges to get rid of all African Americans or all minorities from a jury. That sort of conscious racism is a big problem. We have to do so much more than we've done to deal with it than Batson has accomplished, in my view. But as fundamental a problem are the systemic underlying factors that prevent us from, whether it's conscious racism or not, from really having representative juries, a cross-section of communities' perspectives, ideas, backgrounds, and if that's not being accomplished, whether it's the result of an attorney with what went on in the case that Mr. Monahan talked about, where there's a conscious plot of putting a B before every African American juror's name and striking them consciously. If there are factors that lead us not to have cross-sectional juries, we get a different result. Studies have shown that repeatedly. And if we either value cross-sectional juries or we don't. We either think that makes our criminal justice system more fair or we don't. And if we do, then we should be working as a community in partnership, prosecutors, judges, defense lawyers, law professors, community activists, to make that happen. And we should do all of these tools. And the idea that somehow it's enough simply not to be racist as a prosecutor's office. And I really believe that Judge Wine's office is among the best I know of in not being racist in how they use peremptory challenges, but that's just not enough. It hasn't gotten us where we need to be in our criminal justice system when it comes to juries. Now we have to start thinking about those next steps to take us much, much further if we're going to have the juries that really represent our communities.
Yeah, go ahead.
Okay. And I'm going to address the level of trust with the criminal justice system. I'm from the African American community. I'm actually a member of the independent media. I'm an independent media outlet. And I deal with racism on a regular basis when I'm interviewing people and whatnot. All forms of racism is not intentional, and some people may not even know they're exhibiting forms of racism. So for the black community, as a whole, I think I can say that a large portion of it doesn't trust the criminal justice system. And that's because of systemic things that happened in the past and things of that nature. But also, we have an epidemic in the mainstream media, where this is none of you guys control, but the mainstream media often portrays African Americans in a criminal light. We have rap music. We have all these other entities that portray African Americans as violent criminals. So a lot of times when an all-white jury is sitting there, they can't help but to have these visions in their head. That's why it's so important for African Americans to have other blacks on the jury. So that's why the level of trust is never going to be there if it's not diverse.
Okay.
That's something that's just what it is. I mean,
Okay. We're over time. I was going to do one more question, but I think that's a good ending point. Now, I want to thank our panelists, Councilwoman Green, Commonwealth Attorney Wine, Judge Clayton, Public Defender Ed Monahan, Professor Sam Marcosson. See, I'm looking because I can't remember. I'm getting older. Senator Neal and Chanelle Helm. Let's give them a round of applause. And before everyone leaves, I'm serious. If you want statistics on the state level, then let's get together. It's not going to just happen. We need to get together, figure out what we're looking for, figure out who we need to talk to, and start working on it. It's not going to happen overnight, but if we get together and start pushing for it, it should happen. It needs to happen. But it shouldn't just be we're doing it in Jefferson County and for the rest of the state.
This has been a Metro TV production, a public service of Louisville Metro government.